talked about opinions of witnesses, venue. We talked about what occurred to them, what you think was done wrong, and what injury occurred as a result of that. But now we're not done. Okay? This is before you make the decision to take it or refer it out. And I should have mentioned this earlier. You need to also look at damages. How badly injured was this person? Why is that important? Because they may still have a case if they have a temporary or a small injury. Maybe they fell down in the hospital and they suffered a bad bruise, and 3 weeks later the bruise heals up. And they say, yes, it was because of this person that I fell and I suffered these terrible bruises and I had to be hospitalized and I needed all these things and pain medication. Yeah, but your bruise healed up. It's not permanent. It's not significant. So what do you do then? You say, thank you very much? Absolutely. You can't afford to take on a case like that. No attorney can, because you're spending a tremendous amount of time, effort, energy, and your resources to prosecute a case, knowing full well that the likelihood of you obtaining any significant money for the client is going to be like this. Very, very small, insignificant. So in that instance, you have to ask about damages. So what kind of damages are there? Well, there are economic damages, which is financial loss to the family or to the injured patient, like lost earnings. That's easy to calculate. And we have non-economic damages, such as pain and suffering. Pain and suffering from the time of the event up until the time of trial, and from the time of trial into the foreseeable future. So now you talk to somebody and they tell you, you know what? I suffered a terrible injury where I fractured my femur in the hospital because I fell out of bed. Nobody held me in or strapped me in. I now fractured my femur. I needed to have surgery. I needed titanium rods and pins and plates and screws to hold my bones together. I was like that for 3 months. Then I needed 6 months of physical rehabilitation to teach me to walk again. And now I'm going to need another surgery to take the hardware out. You think that is a significant case? Yes, it is. So there's a huge difference when talking to these people about the type of damages they have. And now let me change tactics a little bit. What about in a wrongful death case? Okay, we've been talking about somebody who's alive and who was injured. What happens in a death case? What type of damages are available? The first thing we want to know is, was an autopsy done? And why? Because we want to know what was the cause of death. Maybe it might show, maybe it will show that something may have been done wrong. On the other hand, maybe it shows that nothing was done wrong. But we typically want to see an autopsy. If we don't have one, it's going to be much more challenging to go ahead and bring a case. With a wrongful death case, we look to see, what did the patient have a conscious level of pain or suffering? If they didn't and they were unconscious, for example, I'll use the Joan Rivers scenario. Joan Rivers was under anesthesia during a procedure when the malpractice occurred. She was not conscious or aware of what was going on, which means that her family no longer had the ability to go after a claim for conscious pain and suffering, which means the biggest part of the case is gone. So what's the only thing left? In a wrongful death case, the only thing left is the pecuniary loss. What is the financial loss to the family as a result of her death? In her case, it was massive because she was earning a tremendous amount of money. So she had the ability, and her family had the ability, to obtain a very significant amount of money based on her financial loss to her family. But most people are not in that situation. Most people that wind up in this scenario don't have money, they're not working, in which case we say, what's the financial loss to the family? And most of the time, it's nothing. They weren't working. They were on Medicare or Medicaid. And now, what type of damages do you have left? Nothing, which is terribly unfortunate. But from a legal standpoint, you're not going to help this family because what's going to happen? You go ahead and try and obtain compensation from Iraq. It's not going to happen. Which brings me to the question of Medicare and Medicaid. We have to deal with these agencies because once we learn that the client was elderly, now we have an obligation to notify them that this person has brought a lawsuit. And guess what? Now they're going to send us a list, line item by line item, of exactly what expenses they paid for this person's medical care that was caused all because of somebody's carelessness. And now we have to negotiate with them. And I want to tell you a story. We're coming to the end, and I'm going to tell you a story about a case that I never should have taken. And I'll tell you why we took it and why the patient got what he did. And it just so happens it's not a med-mal case, but it's illustrative of the point I'm making. A young man was crossing the street in a parking lot going to lunch. He gets hit by a car entering the parking lot, and he suffers massive trauma. He's taken to a local emergency room where he is there for 3.5 weeks. It turns out this young man was somewhat disabled, had learning disability, but was working in a group home earning an hourly wage of minimum wage. So he was functional, but still disabled. The sister calls me within days of this accident happening and says, please, you've got to help me and my brother. He just suffered this horrible injury. He's in the hospital. You've got to help. So I start helping her, and I determined very quickly that the car that hit him had only $100,000 of insurance. And within days, the insurance company for the owner of the car tendered their whole policy. They said, yes, we recognize that our driver was careless. Here's the whole policy. And before I could do anything, the patient gets out of the hospital, and I get the bill from the hospital, $350,000. I learn from the bill, because the sister did not know, she lived in a different state, and the injured patient was unable to communicate. I learned that Medicare and Medicaid paid for almost the entire hospital bill. So what did that mean? It meant that I now had to deal and negotiate with both Medicare and Medicaid to try and reduce the amount that they were going to recover in order for him to walk away with something. Because we would get our fee, which was a third, and now he's left with $67,000, but he's got to pay back out of his own share $350,000. Had I known that at the very beginning, I would have said politely, I cannot help you, because I don't take a case just to generate a fee. We take a case to be able to help you to obtain compensation for the harms and losses that you suffered. So now, months and months of fighting with Medicare and Medicaid and appeals with them turn that lien into the fact that they took almost everything from him. They left him literally with just a few $1,000s. And it was really a shame. It was a shame because, again, had we known that at the beginning, we never would have taken the case. Nobody would have, because it's just not right. But at the same token, Medicare did pay for all of his hospital expenses. So there's a trade-off. So as you are talking to these people, ask yourself the question, are they elderly? Are they on Medicare, Medicaid? Did they pay for the medical bills that you encountered? If the answer is yes, you know you're going to have to negotiate with them. And now you look to see what type of damages they suffered. Are they significant enough to now offset the amount that they're going to have to repay? And again, you're not going to know the exact amount, but just have in your mind the fact that, yes, you're going to have to deal with this during the course of this case. And it's something to keep in mind. All right, so let's see what we learned this morning. If you remember, I told you, and you probably came to this class, to this discussion, saying, you know what, I'm just here at Bridge the Gap. I just need the credit. I don't care about med-mal. I don't do med-mal. There's nothing I need to know about it. But hopefully during the course of this morning's discussion, I guarantee you that during the course of your career, you will encounter people who begin to talk to you, and you'll have small talk, and you'll have conversations with people who begin to tell you their tale of woe. And now you're going to get the sense in your mind that says, you know what, maybe, just maybe, this person has a claim against their doctor. Maybe the doctor was careless. But before you can make that decision, you know now to ask them a series of questions. Instead of asking the open-ended, tell me more, right? What are you going to ask them? That one question. What do you think was done wrong, and what injury did you suffer as a result of that? Now you have in your mind the idea of whether or not there may be a case. And before you go further, what else do you need to ask them? Where did this happen? Municipal hospital? State hospital? Where? Was it a private hospital? Private doctor's office? And then you ask the question, when did this happen? Are you an adult? Was this involving a child? Was it a baby born at birth? Is this a death action where the surviving family wants to know information? And you're thinking, I didn't need to know this. I don't care. Well, you don't. But do you have an obligation? Can you help the person you're talking to? Can you do something for them without getting any benefit or reward? And again, I suggest, as I did earlier, that the answer is yes. Not only will you feel better, but you'll be able to guide them on the path towards getting an educated answer about what to do next. What else did you learn? You learned to think about damages, and you learned to think about venue and what type of witness this person is going to make. All because you came to this class this morning and you thought, I don't need to know any of this. And you're right, you don't. But there will be people who sit down with you. You're at the swim meet, you're at the soccer field, and now you're talking to somebody and they say, hey, you know what? Something horrible just happened. Let me tell you what happened. And just by talking to people, getting to know them, they might open up and tell you about something terrible that happened. And you say, wait a second, I think I might be able to help. And if you can't help them, at least now you know what you need to know in order to refer the case out to an attorney who does this on a regular basis. You need to think about what type of relationship you'll have. Are they going to protect your rights as the referring attorney? Will they keep you in the loop? And by the way, you should ask every firm, hey, how often do you communicate with me to update me and let me know what's going on in the case? Or do I have to nag you every 6 months or every year and say, hey, what's going on with the case I referred to you? They should have a system in place that says, I'm sending you off an email every couple of months saying, here's what's going on in the case, so that you have peace of mind, that you know that something is being done correctly. And that's important when you refer a case out, because the person you're talking to has begun to trust you. And if they're an existing client with something that you handle for them, they already trust you. And now that you're referring them out to somebody else, guess what? They're relying on you to provide them with good information. So I hope this has been useful. I hope you use this in the course of your career. And as always, if you have questions or need to refer a case, I'm available. And I hope this has been a great educational discussion. I'm Gerry Oginski. Thanks for joining me, everybody.